This video will discuss the codification of the civil law in Switzerland. Switzerland is a federal state. It describes itself as a confederation. It's leaving great autonomy to the individual states. They are called cantons, and that's one of the old example of independent entities creating a federation already in the Middle Ages. Some of these cantons are significantly large and others are pretty small. Switzerland is not a large country. You have here a few facts. It's about a third of the size of Louisiana, yet with a population of 9 million inhabitants. It is not a member of the European Union, though it is de facto landlocked in the territory of the European Union. It is also a multilingual state. Though a small country, Switzerland has several, actually 4 national languages that are all recognized as official language. And you see actually these 4 languages on the money denomination, on the Swiss franc. German has the lion's share, but you also have French. The French cantons are on the western part of the country, and most of them share a border with France. And you also have an Italian canton, Ticino, and parts of other cantons where you have Italian-speaking population. And last but not least, you have the Romanche, which is a particular language that is recognized as a national language of Switzerland. Switzerland is also known regarding the law and political organization as a country that historically favored direct democracy. For example, people can assemble on the public square of the main town or city to vote the laws by a show of hands. So that's an example of direct democracy. Other examples of direct democracy is the frequency of the referendum in the various cantons to make decisions on matters that particularly interest the local people. Switzerland has had multiple civil codes. It has been impacted by the French Civil Code because the city of Geneva had been annexed by France, so the French Civil Code was applicable there. And in the first half, shall I say, of the 19th century, several cantons adopted civil codes. That is the case of Canton de Vaud, the canton around the city of Lausanne in 1819. Then you had Fribourg between 1834 and 1850, Neuchâtel, and the Canton du Valais in 1855. The Canton of Geneva tried to adopt a civil code, but attempts did not reach the expected outcome. And until the day when Switzerland adopted a federal code for the entire state, Geneva kept the French Civil Code. It took actually a modification of the Swiss Constitution to allow the federal state to codify private law. They started with a code of obligation. Business was so important for Switzerland at large. It will soon be the home of international institutions, and Switzerland has always been active trading with neighboring nations. And we know also, of course, of the banking activity. It's now the seat of the World Trade Organization and many other United Nations organizations. So this code was adopted in the late 1800s, 1881, and seeing the success of this national codification, the Constitution was modified another time to allow for the adoption of a national confederal Swiss civil code, which was published in 1907 and voted into law to come into force in 1912. This code is largely the work of one individual scholar, Eugen Huber, who was a professor, I believe, at the University of Basel, but had been also a journalist during much of his life and a politician. And he admired the organization of the German civil code that had been published not very long ago and was at the time the most modern civil code. He liked the structure of it, but he liked also the simplicity of style and the clarity of the French civil code. And therefore, he produced a code that is a sort of compromise between two models. It is German by the structure, yet without a general part. I will address that in a few moments. And it has the simplicity and clarity of language like the French model. By the way, like Louisiana, in those days at least, it is a multilingual code because it was written in French, German, Italian, and I'm sure there is a translation in Romansh, though I did not verify that. So this is the initial structure of the code with the law of persons in book 1, family law as the book 2, then you have the law of succession, law of property, and law of obligations. That pretty much mirrors the German organization, though, as I said, without a general part. I'm going to show you the translation into English of Article 1 of this code, and you will see some influence of a scholar that we have discussed earlier in our legal traditions class, the French François Génie. This article is establishing the sources of the law in Switzerland, saying in the first paragraph that legislation governs all matters to which the letter and the spirit of any of its dispositions is related, which indicates that legislation is to be understood according to the letter, but also the spirit, which allows or facilitates the extensive interpretation by way of analogy. The second paragraph is addressing the possibility of gaps in the civil code. What happens if a particular situation is not provided for in the code? A problem that we will discuss much in detail in another class. In the absence of an applicable legislative disposition, the judge pronounces judgment in accordance with customary law. So that refers to custom, which is traditionally recognized in the civil law tradition as one of the main and direct sources of the law. And then in the absence of a custom, according to the rule that he, the judge, would establish if he were to act as a legislator. Now, that is a very, very modern idea that appears for the first time in a civil code anywhere in the world. The idea that if the code is silent, if there is no established custom, the judge has to create a rule by his own initiative, and he has to do this not only with the mindset of a judge having to decide the individual case in front of her or in front of him, but as if the judge were to establish a rule as a legislator. that echoes the methodology that has been described by François Génie in Interprétation et source du droit privé positif. It indeed invites the judge to get the information that legislators would need to make a good decision that could become the general law for the whole country. Typically, by the way, in cases where you have a gap in the law, there will be appeals, and more likely than not, it will be the highest court finally defining the contour of this rule, which will replace, so to speak, the legislation. Of course, it won't have the force of legislation, but it may have a large influence on future court decisions. And eventually, if the legislature decides to create a rule to fill the gap, that may actually inspire the legislative work. And finally, the third paragraph says that the judge, in doing so, is drawing inspiration from the solutions adopted by the doctrine, so looking at legal writing, and the jurisprudence. So the judge has to be informed about the work of the court and past court decisions. This article is regarded as one of the most modern approach of the sources of the civil law. And you see that it is written in pretty simple style. It's not verbose. You recognize here the style that we have seen when reading some provisions of the French Civil Code. And you will find that style also in the Civil Code of Louisiana. I mentioned earlier that unlike the German Bundesgerichtsbuch, Bundesgesetzbuch, the BGB, I stumbled on that. Remember it as the big German book. There is no general part where all rules that may be common to the different books would be gathered, but a very astute provision that we will see later when we study Louisiana law has also inspired the Louisiana legislators when revising the Civil Code of Louisiana. Article 7, which is in the preliminary title, says that the general provisions of the law of obligations regarding the creation, performance, and termination of contracts are applicable to other relationships of private law. That is a very smart way of saying that if you don't have detailed rule, for example, on the creation of a marriage settlement or marriage agreement, or regarding testaments, or regarding adoption, etc., rules of consent regarding the creation of this instrument can be found in the book on the law of obligations, which is, by the way, the earlier code of obligations that has been annexed to the Civil Code. So we are indeed dealing with a great compromise. You get in this code the German precision and the organization of the Pandex, yet with French accessibility and clarity. It doesn't look like a complicated computer as would the German Civil Code, but it has, in a way, the beauty and the simplicity of a Swiss watch. That code, not surprisingly, has a significant international influence. It has particularly influenced the drafting of the Civil Code of Turkey when Turkey became a republic in the 1920s. The Civil Code of Turkey was almost a carbon copy of the Swiss Civil Code. Adjustments had to be made later on in the family law part to adjust, to make adjustment with the leading religion of this country, Islam. And it has been considered by some as a possible model for adopting a civil code for the European Union. There was big discussions in the early 2000s about the adoption of a civil code at the EU level. Yet the project has been abandoned, but there was a big dispute as to whether the EU should adopt the French model or the German model. And of course, the Swiss one was offering the perfect compromise. So this is it for this short introduction, and I will meet you in other videos. Thank you.